Good morning, everybody, and thanks again for joining, and Pierre for hosting a great session. We've had a ton of interest in this topic, where the entire real estate cycle has been disjointed, maybe none more than the ability to do due diligence on properties. And so I'm happy to have Pierre here with us today. And Pierre, thanks as always for lending us your time and being generous with your experience to this end and walking us through what would be a normal circumstance in doing a due diligence, and then how again you're able to do it in these times. So thanks, and I'll let you run with it from here.
Great, thank you guys. Thanks everybody for, as always, every week for having me. And again, I hope you and your loved ones are all healthy and safe and hanging in there. Those of you guys, I believe probably everybody on this list is familiar with what we're doing at this point. For those of you guys who may not, we've been coordinating NYRAC exclusive events on a weekly basis with a combination of Q&A sessions and continuing ed classes. And as you guys know, our continuing education provider, the New York Real Estate Center, is actually one of your organization's sponsors. And we've been issuing CE credits through the New York Real Estate Center. And I just looked up my schedule for May. We have 11 CE classes already scheduled for May. So by the time this pandemic's over, I joked this morning, so I'm already sick and tired of saying the word Zoom. I've never used the word Zoom so much in my life than I have this month. So it's been a lot of fun though, to be all kidding aside. It's been a great way for us to connect, stay in touch, talk about what's going on, and just for me, I can tell you, I'm closing my window now because I have a 3- and a 5-year-old that, if those of you guys have been taking my classes, know they crash every single time I do this. So I'm trying to barricade them out of here. So that's another disclaimer if you see two little midgets jump on top of me in the middle of this. But in going through this, guys, I want to kind of keep this one an open dialogue as well. This is a topic where there's a lot of basic components to due diligence and a lot of unique aspects to it given what we're going through right now. So by all means, Friday morning, I'd love nothing more to make this more of a fluid conversation with you guys. Hear about issues you guys are encountering, hear about deals you've recently worked on that maybe any of the topics I touch upon related to some of your deals and stuff like that. So talk about due diligence, right? It's a phrase we use all the time, up and down, left and right. And what does it really mean? What are we really looking for? Clearly the main aspects of this are that we always obtain the offering plan for the building. We always obtain the financial statements for the past 2 years. We review the board minutes for every single property that we're doing a transaction, or every single building, I should say. We send a very detailed questionnaire to the managing agent. And then we summarize our firm. I don't know how many of you guys have seen this memo. Our firm sends every buyer a 10-page PowerPoint presentation summarizing our due diligence. So it's basically put in plain English. We do this for resale co-ops and condos, and for new development sponsor purchases, and a different version for townhouses and multifamilies. But essentially what we're trying to do is synthesize all this material into a comprehensive memo that's really put in plain English. It's not written in legalese. It breaks down everything very concisely. Out of 10 pages, no page has more than 3 bullet points to it, and no bullet points more than 3 sentences. So it's really like to the point, what you need to be aware of. And it is for multiple reasons. One, we firmly believe that one of our biggest duties in representing a buyer is advising them on risks associated with the building that you're making investment in, right? Like you're making this investment in a co-op, you're investing in shares in a corporation. You want to know what's the financial health of the building. A lot of, stuff you guys all know. Secondly, quite honestly, from experience, I don't know if you guys were on my agency disclosure class I did 2 days ago. If anyone was there, I emphasize a paper trail. And I use that phrase, emphatically, because a lot of the due diligence, if we got on a call with a client and just ran them through what we found, and in 90 days we close and some adverse information comes out, negative news, and the clients will say, well, you never told me this. We don't have a paper trail. And, quite honestly, that protects both you guys and us, as licensed professionals in this stuff. That, look, we're living through it now in this pandemic where whenever you see any tumultuous time in a marketplace, you see the real side of a lot of people. And I have couple clients right now where I can't tell you, it's just arbitrarily pointing the finger wherever you can to get what they want. And, and us, you guys and us are the first two people that they're going to be pointing fingers at. So a lot, just to, give you background why we focus so much on putting this memo together. Now, the first aspect is the offering plan. I don't know, you guys, Heather McDonough taught a great class 2.5 weeks ago, I want to say, on offering plans. I don't know if any of you guys took it. I moderated with her. It was a pretty cool class. And we focus on the basics of the offering plan. What's the purpose of it? But we do so on a new development, from a new development angle. Now, clearly, as time goes on, one of the most frustrating things for you guys, I'm sure, is locating the offering plan for a co-op that was built in the 70s or 80s. And the offering plan hasn't been amended since, the first Bush was in presidency. And what's the relevance of it, right? And you're tracking it down. Number one, a great source. Nick, I think you should talk about your offering plan library if people don't know about it, because I can tell you it's our saving grace in trying to find stuff. But, you guys, in getting a listing, you want to make sure you get all these materials in advance as possible. The offering plan and all the amendments. The amendments are key. Quite honestly, as time goes on, the offering plan loses its relevancy. It does become a little bit obsolete. Now, with that being said, we still review it. I have to go through the main aspects of it just to confirm in case there's, and in that slim instance there's something material there, I can't miss it. So Nick, you do me a favor. Can you talk about the offering plan library for a couple minutes?
Yeah, more than happy to. TitleVest, for all the reasons that Pierre just said, TitleVest took initiative to start hobbling together a library of offering plans. And, instead of attorneys having to take them back to their office and building their collection, we said, hey, we'll take that thing off your hands for free and build our own tech library of it. And the actual amendment, the documents itself, plus all of the amendments that would bring the offering plan up to date. So today, multiple years later, we have the largest offering plan library in New York, which is fantastic, and make it fully available to all of our clients through our online mechanism. So it's been incredibly helpful to agents and lawyers alike who are looking to get the most up-to-date information on new developments, as well as resale condominium complexes.
And how many plans do you guys have?
I think 3,000.
I think it's more.
Yeah.
It's more. And you keep current with all the amendments, right?
We do, which is one of the best parts. That getting your hands on an old offering plan is easy. The amendments are the tough thing. So that's, I would say, the best advantage of the program right now is the access to the most updated amendments.
Now, for those of you guys,
only, isn't it though?
Pardon?
Because we have used that for quite some time now, and thank you so much for putting it together. But I believe it's a read-only library, right? In other words, if we need to get an offering plan to someone's attorney, we can find it on TitleVest, but we can't access it to give it to another attorney.
You can at a cost. So we offer a read-only version, which is generally what the attorney needs, is just a read-only version of it for free. And then if you print it, there's a distribution cost.
Oh, okay. I didn't know that. Sorry, didn't know that was involved.
Yeah. No, it's totally okay.
Nick, if you can put in the message board, people are asking for the website for it. If you can put that in the message board.
I absolutely will. Yeah. Give me just
so
a couple
guys,
minutes.
the reason I emphasize this is because I embrace the fact that when you get a listing, chances are an owner probably threw this offering plan away or doesn't have it. And if it's an older building or somebody that's owned in the building for a long time, also too, dealing with managing agents has always been, to put it politely, an arduous task when it comes to due diligence. And I don't think that's going to get better during this pandemic. So having everything electronic and streamlined is more, is more important now than ever. And I think that the trend that we're going to start going down. I can tell you, I use it. I don't require a hard copy. A digital copy is sufficient for my purposes. Some other lawyers out there probably aren't going to be as accommodating and require a hard copy. But as long as we have a copy we can read and we can send it to our clients to keep for their records, we're good to go. Now, what is the purpose though of the plan? Let me throw that out to you. Why do we have offering plans? Like, why does the AG require this? Like, what's the whole premise for having this is a requirement for a developer? So basically, the one thing you have to look at the Attorney General. Attorney General is there kind of to be. I always view it as a protector for the consumer, for our buyers. The way they view this, in a sense, to break it down, in an elementary way, is that the developer, they look at the developer as basically a sophisticated, savvy person who is coming up with this project, and the consumer can be a novice in many ways and doesn't know what's entailed in buying into a building in a new development. And due to how this works out, here are 100 pages of regulations and a 500-page offering plan that you have to file to put every single buyer on notice of every conceivable thing that could take place and how it works buying in a new development project. And the AG regs serve as kind of like a protection, a layer of protection for the consumer. The offering plan, about 500-page book. Does anybody read all 500 pages? Quite honestly, the answer is no, because we really go through the relevant sections, and more than 50% of an offering plan's exhibits. So for instance, the contract of sale that we use is an exhibit. All the floor plans are exhibits. That takes up hundreds of pages. We have to know really where to focus on in a plan and what we're looking out for. So what are the main components? The most important part of an offering plan is a special risk section. Special risk is about probably 20, 25 pages, depending on the building. A good chunk of it's disclaimers and standard disclosures, and the rest of it is really where, the meat of the offering plan and what you really want to be aware of is contained. So, reading special risk is imperative. If you guys took my new development offering plan class earlier in April, I focused 75% of the time on special risk. And what are we looking for there? We're looking for any unique aspects of the project, anything that could, basically it goes through lot line windows, it goes through sponsors' rights and obligations, it goes through sponsors' control of the board, it can go through any unorthodox structures of the property, if it's a hotel condo, if part of it's a condo, part of it's a hotel, how they share in costs, things of that nature. And that again, most important section. We go through Schedule A. Schedule A is all basically the numbers of the building, square footage, percentage of common elements, real estate taxes, taxes with an abatement, taxes without an abatement, common charges, things of that nature. Want to focus on that. For those of you guys who do resale listings and you're indicating square footage, you get the square footage off Schedule A. So always go to the most recent amendment in a plan where Schedule A is contained, and that's where your square footage is. That's really the reason why in a condominium listing, you can list square footage there, but in a co-op resale listing, you can't list square footage. Does anybody list square footage in a co-op listing?
Hi, Pierre. I will list square footage for a co-op especially if it's a loft and it's very, very clearly defined, the measurements. But I don't list at co-ops. I do a lot of deals, like for example at 2 Fifth, and I never list the square footage. The downside, the upside in a way is that there's so many historical listings in 2 Fifth where the brokers have exaggerated the square footage. So it's actually better for me not to quote the square footage because they go to these old listings and they think the apartment's bigger than it is, which is kind of funny, I think.
Well, Sean, why do you do it in a loft?
Yeah, I quote the square footage when I have it from another source, so in a co-op. So if I have a floor plan guy, when my floor plan guy comes in, I ask him to give me the square footage, and we use these guys that do it in a particular way that, I don't know, that we believe it's true at any rate. And we got it from another source. So if someone says to me, well, you gave me the square footage, so I got it from this floor plan and measured it with a laser, what am I gonna do?
Well, Harry, do you disclose where you got it from?
Our disclosures say that the information that was given to you is gotten from a third party, and we don't know for sure that it's true, and you should check if you want to know for sure if it's true. So granted, if I get a number back from a floor planner and the number is like seems ridiculously high or ridiculously low, then I usually don't go with it because I just figure, well, and if I have a whole bunch of apartments in a building that were all listed at a certain square footage, let's just say my floor plan guy comes in with a lower number significantly, I realize that like the other person said at 2 Fifth Avenue, which I've sold in before, that the other people exaggerate, I just leave it out, let them find the wrong information somewhere else. But if I have what I believe is the right information, I will list it.
So Harry, it's a little risky because you're relying upon an independent third party who it may not be crystal clear that that's where you're obtaining the information from. And it seems like there could be a pretty big disparity in what the actual square footage is. And, if you have that disparity, how you're assuming a bit of liability in the event that, you're over exaggerating the actual number by a substantial sum. It is, look, we all know square footage is probably the most sensitive aspect to what we do. Consumers fixated on price per foot. It's become an obsession for people. I get why it's so important, but at the same token, given the magnitude of it, you got to be really, really careful. I mean, if you are taking it from a measurer or floor plan person, you want to make sure it's crystal clear you got this information. It's for informational purposes only. Sorry, that you got this information from X, Y, and Z independent third party, that it's for informational purposes only, and the buyer can verify it upon their own will.
Well, isn't that true for information from an offering plan? You got it from a third party.
Well, it's a little different.
I believe it's true.
It's a bit different because a floor plan measurer guy or woman may have more of a vested interest in help. Let's just play this out, right? And nothing having to do with you personally. But if you have somebody you use for all your floor plans, and you're like, hey, do me a favor, be liberal on this one. There's a higher probability.
I would never do that. Okay?
Not you. That's why I said.
Do that.
That's exactly why I said not you personally. A listing agent, you can manipulate a person who takes floor plans more than you can the AG. You can't manipulate the AG. The AG is the AG.
The AG didn't do the floor plan measurements. They didn't quote the square footage.
That's what I'm
not
saying.
True.
No.
The AG has nothing to do with the square footage measurements listed in an offering plan. It was done by another floor plan type person who estimated the square footage, just like my floor plan guy does.
But it's approved by the AG. It's approved by. So that's a different.
Yeah, the AG may have approved it, but the AG isn't saying this information is correct. Well, that they haven't gone there and verified it. That's all a bunch
of course
crap.
not.
Except
the problem is that when people don't list square footage overall, and all these co-ops are out there with no square footage because people don't want to have a proper floor plan done with proper measurements in a standard way. And if we standardize the way that we do floor plans across the business, then we could point to a standard that we use. The problem is that we currently use various standards, and that's the problem. If every floor planner that did a floor plan used the same methodology, I think it would be a lot more accurate for the industry.
I wholeheartedly agree. I mean, that's one of the initiatives of your organization is to have transparency on stuff like this. There has to be, at some point in time, there has to be a uniform way of measuring and disclosing and listing square footage. 110%. The reason I'm harping on this is that from a liability perspective, if you list what's in an offering plan in a condo, you as a licensed professional protected, right? Albeit the attorney general is not going to go to every apartment and measure to confirm. You have a legal source, a legal document you're relying upon. That's the difference. Now, when you get independent measures in there, there's 50 different ways to measure. That's where the risk lies. That's the problem.
I get that there's no risk. And I know that if the offering plan, condo number is ridiculous, I list it anyway, because that's what it says. And I don't have a problem with it. I never worry about it because I know I'm protected in that way. And I feel like if we don't list these square footages, we're doing the consumer a disservice. If we believe they're true, If we believe they're not true, and we're just trying to get a leg up on the size of our one bedroom, and it's 1,000 square feet instead of 850, that's not okay. So there's a big difference between listing something you think is true, that you got from a reliable source, in my opinion, than there is in sort of making it up.
It's a risk. It's a risk, to be honest. But let's move on to a different topic, because I want to talk about some duty to disclose. Now, if you're on a listing agent side and you're aware of any material information that a buyer would want to know in making a decision whether to buy your property or not, you have to disclose it. You can't rely upon the fact that merely the fact that buyer has to get an attorney, that attorney does due diligence, my hands are clean, it's up to them to figure it out. If you have concrete knowledge of something that would be deemed to be material, you have to disclose. I'll give you a great example. Part of the reason that we always look at the offering plan is that we look for lot line windows. Lot line windows is another extraordinarily sensitive topic in what we do. And there's 3 places where you predominantly find this: special risk, the engineer's report in part 2 of the offering plan, and on a floor plan, sometimes you'll see an LLW next to a window. Back in the 80s, for those of you guys who've been doing this for a while, you remember the chicken wire windows. Chicken wire was supposed to indicate, that was a lot line window. And luckily, we became a little more sophisticated and valued views a little more, and we got rid of the chicken wire in a lot of buildings. But I'll give you one great scenario. I didn't work on this deal. I heard this through a friend in the business. There was once an attorney who was doing a resale of a condo unit, and he didn't read minutes. And the offering plan, nor did he review the offering plan. It was probably a property that was built, a new development from like 7 years ago, roughly. And the offering plan discloses lot line windows. The board minutes disclosed the fact that there was discussion of construction taking place that will impact those lot line windows. And the agent had knowledge that there was discussion going on of construction that would require those windows to be sealed up. No one ever, the buyer's lawyer missed this, and the agent didn't disclose this to the buyer when negotiating the deal. Now, a lot of people say, well, why is that my job? That's why they hire a buyer's attorney. Again, as a licensed professional, there's a duty to disclose if you are aware of any information that would be material. So in this scenario, the buyer's lawyer got sued for malpractice. When you take what you guys know better than I do, the views in New York City could be worth, millions, depending on where you are. If you take a room and you seal up those windows, number one, it's not, if the windows are lot line windows in a bedroom, it's not a real bedroom, because a real bedroom can't have the risk of not having air and light. Number two, in this scenario, it was a living room, and it was by far the best views of the entire unit, and they lost them. And that's a multiple $100,000 lawsuit that I'm sure the lawyer's malpractice insurance covered, and increased his premium drastically. So just always keep that in mind, that if you know of anything, there is a duty to disclose. Anybody have any examples or hypotheticals on this topic? Because I know the words material information and stuff like that are leave a lot of room for subjective interpretation.
I actually do, back to the square footage question.
Okay.
One of my pet peeves are these full floor lofts where the offering plan quotes a square footage that's inclusive of the whole floor, including the stairs and the elevator. Mm-hmm. And that's in the Schedule A. I believe there's usually also another square footage number without those included, somewhere hidden in the offering plan. So when you disclose the square footage, and and you should know that it includes, because it's pretty obvious the apartment's not as big as what you're quoting, right? Do you feel that the agent should say that it includes the elevator and the stair?
I would say, please review the offering plan to know the formula for how this is calculated. Less is more in your situation, as long as you give the proper disclaimer. To be honest with you, the offering plan, when they measure from the exterior of the building, which takes into account the width of the building, beams, and oftentimes, you know, common areas. So a new development, for instance, the usable square footage is typically up to 10% less than the number in Schedule A, just due to the nature of the formula of measuring. So, you know, it's something that it gets, and I've seen a couple plans where people got really cute trying to play with the formula even more. I had a client once that actually, I forgot how he did this. Before he signed his contract on new development, he went in on his own and he used some app that like measured the unit, and that it showed that it was 25% less than the number in the offering plan. And when I tell you the description of the formula was so convoluted, I couldn't even comprehend it. You know, it was just, they really played with it and tried to manipulate the regs to grossly fabricate the square footage. So you don't want to be in a position where you're describing the actual formula. I would just disclose to them, you know, it's in the plan, please see the plan to verify. I would leave it at that.
Okay.
Does anybody else have any thoughts on the square footage different than what we've discussed, or any other policies? Like I know some companies, company policy is on a co-op, you can't list it. And I know other people say, you know, I hire an independent person. Any other viewpoints on this before we move on?
I do have a question on disclosure that came from the audience.
Mm-hmm.
And they would like to know if a broker is required to disclose that they know that there will be major construction in the foreseeable future, though that information is not broadly known. Does the listing broker have a requirement to disclose?
If you're aware of it and it's more than just hearsay, yes, there's a duty to disclose. It depends where you got it. The person who asked that question, can you give me a little more info on the hypothetical? Where did you get the info from? At what stage is the construction at? Was it a conversation with a board member? Was it just rumors you heard in the lobby? You know, a little more info would help on answering that one.
Monica, if you want to unmute yourself, go right ahead.
Hi. It's a possible conversion project on the same block that will most likely occur within the next few years. It's not filed, it's not anything. It's just a possibility.
How did you find out about it?
I've been doing what I've been doing a long time. I know what I know.
Is a conversion project? It's a conversion. It's not ground up, but they're going to extend the height of the building. Is it impact?
It may turn out to be ground up. It probably will be ground up.
It sounds like you have some concrete info. I would disclose it. You know, to be honest with you, you better.
Really, like if it's not filed, if it's not a fact, if it's not anything truly concrete at this moment.
It's a tough one, Monica, because you're being a little vague on the details, right? Like, I need to know how you found out about it. Pardon?
I'll call you later.
All right, yeah. Well, let's chat about this one offline. But I also want to give you a good scenario, and I had this happen recently. If you're in that boat, Monica, I was in that boat not long ago, where it was at a very preliminary stage. The broker disclosed that there's going to be new construction across the street, and our client was worried how would that impact their views. What we do, you know, for those of you guys who've taken our air rights and zoning class before, you know, air rights and zoning is an extremely, extremely difficult topic to address, because we can't predict how certain parts of the city will be rezoned in the future, and how air rights transfers can take place to continue erecting certain properties higher and higher and higher. So the way we go about it is that if clients are very concerned about this, they have two options. One, they can retain a zoning lawyer, which costs a lot of money and does not give you the absolute assurance that you're going to be looking for. And number two, Nick's company, TitleVest, does what's called a sightline report. Nick and I presented on the sightline report at various power hours, if you guys have attended those by chance. And the sightline gives us an assessment in terms of what the current zoning is, what the current floor to area ratio is, and what's the maximum height that the building could be erected, regardless of how much air rights that developer may acquire. And that report has saved many deals for me when I've been in the position of like what Monica's saying, where there's speculative development that's taking place, and people are worried about their views being completely lost or compromised. So it's a great service. I highly recommend it, guys.
Hi. Yeah, no, I'm aware of that. And I have done that before with TitleVest, and it's a great service. This is more about dust and noise and disruption. I don't believe it will really impact anybody's view. In fact, it may make their light better.
If it's just the fact that there's construction going on and you're worried about noise and dirt, I mean, it's New York City, like I said, like that. There's always construction everywhere. It really just depends on will it have a material impact.
But if you want to buy a house and spend many millions, yeah. But the truth is, the people who buy this house are also going to be creating dust and noise for their neighbors. So never mind.
Let's chat about that one offline.
Okay,
all right, so I want to move to financial statements. Financial statements are again one of the most important aspects of our due diligence because we need to ascertain the financial health of the building. And when I say that, clearly we have a lot of clients who are in the financial services industry, and they look at these financials, and a lot of buildings operate at a loss. And when you go through financials, operating at a loss necessarily a bad thing. And people look at it and they'll say, well, we'll have clients every now and then. I want to see the financials myself. I'm like, how could you take me to buildings operating in the red? There's too many variables to make a black and white assessment in terms of whether that's negative or not. Keep in mind, we preface this all the time. These buildings are not for-profit buildings. In a perfect world, they operate at a slight surplus where they can take that surplus and can replenish the reserve fund every year, add to the reserve fund. If they're operating at a significant surplus, chances are common charges or maintenance are way too high, which has a negative impact on valuations, and the board's actually doing a disservice to the building. So if there's a loss, the reason we asked for the last 2 years of financials is that I want to go through the statement of operations and compare and contrast multiple years, because 1 year could be a loss and the year prior was a surplus, and the reason 1 year was a loss was because of an isolated incident and expense that took place that would not be reoccurring. So it's not, again, black and white of just look at the bottom line. You have to go through the expenses and see what exactly came up that caused that loss to take place in that given year. So when you go through it, for instance, if there's a major capital improvement they undertook, and that resulted in a loss, and the building used their cash flow to pay for it, as opposed to depleting the reserve fund, then I want to go see what's left in the reserve fund. And typically speaking, as long as they're not, we'll divide their cost of operations by 12. And as long as they're not more than 3 months of cost of operations in the red, and there's a decent reserve fund, you're in a pretty good shape. It all depends on what's in the reserve fund and exactly what caused that red. If the reserve fund's 0 and you're operating at a red by 3 months or more, and you've been operating the red for a number of years, then it's a poorly managed building. So always you want to analyze financial statements closely. I got an email with a question that was a really good question. What happens with a small self-managed building that may not have everything buttoned up like we're describing? I'm sure we've all encountered this where our clients buy in a 3 to 5 unit building, and the building doesn't do financial statements. All they have is tax returns. To be honest with you, we can only work with what we have. In this scenario, we go through the tax returns and we see, I take a look at tax returns the last 2 years. What income did you show? What loss did you show? And we try to get in touch with the board president and ask them 100 questions. There are many buildings out there that are self-managed, that don't, invest the time to keep proper, documentation of the operations of the building, that may not be operating it well to begin with. And we just have to really dig through everything we have. I always say my job as a buyer's lawyer is not to tell a buyer what to do. It's to advise them of the situation, educate them, try to provide them with all the solutions for mitigating risks, and then it's their business decision to make. I've been in scenarios where managing agents will tell me this co-op does not allow you to access board minutes. I've had that come up. I've had situations where we will not answer a custom questionnaire, we'll only answer generic. There's a number of scenarios. We just have to do the best with what we can, and it's an our client decision to make. Yeah.
Question. I'm in the midst of a deal of a building that has 3 units. And of the 3 units, my sellers are both, one is the president and the other is the treasurer of the board. They
Yeah.
only do tax returns. They don't do financial statements. So who do you speak to? The accountant who's prepared the tax returns? That person's not going to be able to give you answers on how the building is run.
Right. The third board member is the one who's the independent party in this scenario.
No, I'm saying there are 3 units. The unit that we're selling is owned by a couple, one of whom acts as the president and the other is the treasurer of the board. So the other 2 unit owners really don't know anything about and they're happy not to know how the building is operated. They just want to know that they're living there and everything's okay. So where do you get your information from?
That's a very tough one, because clearly the seller has a conflict of interest, right? They're not going to disclose to you anything that's negative. I was confronted with this a couple years ago, and exact same scenario where the other unit members. I mean, look, when you're a 3-unit building and there's 4 people in the building, there's no real board. Let's be honest. 1 or 2 people are assuming all the responsibility of running the building, and when that person goes to sell, that's when we're in trouble. And we had to rely upon the seller in answering our questionnaire and providing us with information and talking to the accountant. I don't even think they had legal counsel, and even if they did, the legal counsel probably wasn't that engaged in the building. And we told our client, like, look, we got this information from an interested party. It could very well be inaccurate, but it's all we have to rely upon in buying in a building like this. It's again up to you. It's up to you whether you're comfortable, with this. This is the most we can uncover. There's nothing else really you can do. I wouldn't scare them off and say, look, the main things, what are you looking for? The main things in a small building like that, I recommend doing an engineer's inspection. I recommend an inspector in there, because any unit, I like to say a building of 12 units or less, I recommend an inspection. Otherwise I don't, because if something does go wrong in the building, clearly, when you're dividing up an assessment amongst a small crop of people, it's a high number. So that you're worried about the condition. Then the other thing, you're worried about financials. If we get our hands on the tax returns and we can have a conversation with our accountant, we can at least gauge what the financial health of the building is. Maybe we can rely upon the board president, the interested party, to tell us what's been the history of, common charge or maintenance increases. So those are the next thing I should say is what upcoming capital improvements are taking place and how are they being paid for? That was hard to answer, because we'll rely a lot on the engineer's inspection to see what needs to be improved in the near future. And that's where, the board president / seller could be a little dishonest. But if we can carve those out, at least we made some progress. It's not foolproof, but it's something concrete to present to the body.
Okay.
Cool. So to keep going through financial statements, I want to also talk about, it's not just numbers in terms of, the cost of operations and income. Always, and I recommend this in a listing too, to be honest with you, go through the notes in the financials. If you get a listing, first thing you want to do is obtain all these materials. So you can just have them in a package with a bow on it and give to the lawyers so they can't say like, oh, we have a delay because I'm waiting on X, Y, and Z. And then take a quick look, glance through the notes. They're maybe 3 pages long. Again, a third of it's probably just regular disclaimers and disclosures, but it'll tell you if there's lawsuits. It'll tell you if the commercial tenants have leases when they're expiring. It'll tell you the building's a land lease. It'll tell you if the underlying mortgage is coming up for maturity. It gives you, real information you need to be aware of. And the reason I harp on this is that, we're going to go next to the questionnaire and board minutes, but, for those of you guys who have read board minutes before, if I say 1 out of 10 times I find them to be beneficial, that'd be generous. Board minutes for the most part are very vague. There's no legal parameters for requiring what must be contained in them. And oftentimes they're not even up to date. So the notes help you out a lot. And let's go through those components. why do I care about the commercial leases? You know, right now we're in a retail crisis. If your building is operating with substantial retail vacancies, the commercial tenants, that's a tremendous loss of income that you have to forecast for. And if there's going to be a prolonged vacancy, chances are there's definitely going to be a maintenance increase. So you want to look at that. And then also clients are going to walk by the building and notice, you know, huge storefront on the corner is vacant. What's going on? It's good to maybe then go to the managing agent and be like, look, what's the status of filling up the space? The more info you can get, the better. Second, if it's a land lease, you want to know the terms, right? Land lease buildings are hard sells. You know, if the financials, the notes will give you a quick summary in terms of what you need to be aware of. What do you care about? How many years are left on the lease? When's the next rent escalation and recalculation? And are there any renewal options? The notes will give you that info. It's invaluable. You know, it really is. Litigation. Litigation is a huge one. I use this example, and it's a great story. About a decade ago, I represented somebody buying a 25 Sutton Place South. For those of you guys who know the building, it's situated above the FDR, and it has like a retaining wall on the side. And that retaining wall, debris fell off that wall onto the FDR and caused a number of car accidents, and people sued the city up and down, left and right. And then the city came back and sued the co-op, claiming that the co-op failed to maintain the retaining wall in the structure that it's situated on in the appropriate manner, which caused this damage. So the city sued the co-op for $38 million. This wasn't in the board minutes whatsoever. It wasn't in a generic questionnaire. And I luckily found out about it before I sent my custom questionnaire in. It was only in the notes of the financials. That's it. That's the only place we found it. Now, how do we analyze this, right? $38 million lawsuit, A, is a huge sum of money. B, the city's the plaintiff. That's pretty scary, right? The government's probably not going to lose in a lawsuit against the co-op. And C, how would the judgment be paid should a court of law rule in favor of the city? So in this scenario, I was at a very preliminary stage we were at a very preliminary stage of the lawsuit when our client was looking to buy the property. And at that time, we didn't have any more information than a complaint was filed against the co-op. So the way we assess the client, you know, we look at it like, okay, A, does the co-op's insurance cover this or a portion of this should the city prevail? B, everybody who files a lawsuit, their alleged damages are usually grossly higher what actual damages are. So chances are $38 million is pie in the sky in a sense. And C, even if I'm wrong, what would be our client's max liability? So we took her shares of her unit divided by the total amount of shares in the building and took that sum and multiplied it by the potential $38 million. And so it came out to her risk was going to be about $250,000 assessment on an absolute worst case scenario, right? $250,000. Chances are lawsuits settle. So it'd be a lot lower in a settlement, and then the insurance will cover a part of it. So that delta between reality and the $250,000, I couldn't give any guidance on whatsoever. Client calls me up, just, Pierre, what would you do? That's the worst question you can get. What would I do? You know, like $250,000 to me may be a lot different than $250,000 to you. I can't tell you that, you know, it's your decision to make. So ironically, this is before the financial crisis. It's when the market was skyrocketing. And she goes, well, fine, I'm going to sleep on it. I'll let you know. And she sleeps on it. Someone comes in, outbids her by 6 figures. She wakes up, ups her bid to outbid that person, signs the contract, closes, and I never heard from her again. And the beauty of that is it means it had to have been resolved well, right? God knows if she made $250,000, she would have called me and given me hell. I never looked up. It's been years. I got to look up how it was resolved. I don't remember. But the mere fact that we never heard from her again means that it was resolved in a positive manner. So, you know, again, notes in the financials. And if you see something like this, what am I asking for as a buyer's attorney, right? I ideally want an opinion letter from the council of the building as to what their view is on the legitimacy of the lawsuit. because not all lawsuits are, you know, are very, I should say, troublesome. Oftentimes there's slip and fall. Slip and fall, we don't care. There's insurance. Insurance covers it. If it's construction defect, we're extremely concerned. I want to know exactly what's the nature of construction defects. Have the defects been paid? If they've been paid, what's a co-op's or condo's financial situation with having outlay that money? And if they're suing to recoup money, then it's a win-win if they're in a good financial boat, because all the award they receive is going to go right into the bank. So you have to really analyze lawsuits from a number of different angles. There's no, again, black or white way. And keep in mind, banks require an exception on a mortgage if the building's tangled up in a lawsuit. So it's even a step further. It's not my level of comfort. I have to make sure that the bank has a level of comfort with the lawsuit to be able to get that exception. So it's that's why I keep emphasizing it's great to just skim the notes and see if anything jumps out. And many of you guys over the years have called me and be like, "Hey, Pierre, can you take a look at this page in the notes? Like this popped out. What do you think?" You know, more than happy. Adam, you got a question?
Yeah, Pierre, if the co-op or condo doesn't own the retail, do you still dive into it at all, or does it not matter at that point?
Doesn't matter as much as long as the maintenance and common charges are being paid. You know, so sponsors in condo development, oftentimes they almost always keep ownership of the retail space, and they maintain a seat on the board because of it. As long as they're paying their common charges, you know, we're not as concerned. But let's be honest, a prolonged vacancy, you know, compromises their ability to pay common charges, you know, depending on the developer. So it's not as detrimental, but you want to be, and clearly the common charge revenue won't be as high as the commercial rent. So if the building owns a space and is losing the commercial rent, that's a lot bigger of a hit to their financials than losing the common charge revenue from that space. You know what I mean?
You report on like exclusions about kinds of tenants they're not allowed to take if it is vacant. Is that part of your due diligence?
No, we don't. We don't. It's too hard to tell. It'd be too difficult.
Okay.
I couldn't make any real assurances. You know what I mean?
Right.
So I want to talk briefly about board minutes. Not too long, but you know, board minutes, again, like I said, we read them on every single transaction. And they do not contain nearly the amount of material information that we would hope they would. The business corporation law doesn't provide parameters for what must be disclosed. Boards can, you know, they'll decide to meet semi-annually. Diligent ones meet monthly. They can decide if there's adverse information they don't want it to be disclosed in the minutes. Now with the COVID crisis, we've got a number of deals in contract during this time period. And luckily, a couple of managing agents have actually been amenable to emailing us the board minutes. And historically, they wouldn't do that because they wouldn't want them to be out there, you know, for the public to have in their possession in the event that our buyer did not proceed with buying in that building. I think for the foreseeable future, you're going to see them come around and email minutes because, you know, I'm hoping it becomes commonplace because there's going to be a huge trend, even when this is, you know, over, if we've made more progress than we've already made, of eliminating, you know, human interaction where not necessary. And sending somebody to a managing agent's office to sit in a corner of the conference room or the lobby reading board minutes is probably going to become something I'm hoping that becomes obsolete, and they can streamline it. It'd make our lives a million times easier.
Pierre, couldn't the managing agent just solve this problem by asking you to sign a non-disclosure statement, just like we're asked to sign non-disclosure statements at times, and right?
They you know, they could. It just, I don't want to disparage anybody, but they're not accommodating. You know what I mean? Like they're difficult. They don't care about us. Like we're not paying them, right? They care about the board. You know, they're very unaccommodating to us. You know, like I'm starting to get questionnaire fees of like $500. I got one recently, it's like $500, and they take like 2 weeks to answer it. It's like, who has 2 weeks to wait? Are you out of your mind? And $500, what an egregious sum of money. Like most of the questions are yes or no answers, you know? But for them, it's like, man, you know, what are you gonna do?
Wow.
We don't care your deal takes 2 weeks extra, right? So yeah, logically speaking, you're right, Sean. Like, you know, give us something to sign that we, you know, don't circulate them and don't advertise what's contained in them, you know. But well, you know, we'll see. So in any event, when I want to kind of, you know, so on the board minutes again, as much as I'm, you know, describing how they're not as reliable as we would hope, it's still imperative to always read them, because look, in that 1 out of 10 instance or something material there, I can't miss it, right? I can't be in the boat. You know, we're doing hundreds of deals a year. You know, if you do the math, you know, that means, you know, 10 times a year, there's something substantial in there. So it is important to read it on every deal. Now, where I'm going with this is that I want to go, this brings me to the importance of our questionnaire. The questionnaire is the hardest part about getting our due diligence done in a timely manner, because the property managers are always reluctant to answer them, and even if they're charging a fee and willing to do it, it's never promptly. If you get a listing, obtain all the due diligence materials in advance, including asking for a generic questionnaire. Even if it costs $100 or whatever they may charge, get the generic questionnaire. It saves time, because if I'm in a time crunch on a deal, you know, we've all been in situations where we've had to get deals done and signed in 24 to 48 hours, right? And if I'm in that time crunch and I get a generic questionnaire and I read the minutes and I read the financials, I can go through that generic questionnaire and check off my list what I'm really concerned with the building, and tell the client, look, I don't have these 5 to 10 things answered. However, they're not the most material aspects of our due diligence. Here are the most material. You know, if you want to proceed on this 48-hour deadline, you can, knowing that you have most of the most important information at your disposal. However, we don't have this. And if you think that what we don't have is extremely material, then you have to roll the dice and, you know, see if you don't meet the 48-hour delay. If you know, look, what am I talking about in terms of immaterial? I should say immaterial. Let's say second tier of importance. I'm asking the managing agent, is any leaks taking place? Any mold? Any upcoming, any historic maintenance increases? Stuff that you can say, okay, my contract has a rep that there's been no leaks or no mold. I'm okay living with that rep. That rep doesn't survive closing. So while I'd like it for it to be from the managing agent's mouth, you know, it's a calculated risk. I'm not going to kill a deal over something like that. So if you get all this information in advance, you help make our lives much easier and avoid any delays. And even if there's a custom questionnaire, you know, I ask, it's the first thing I ask. I get a deal sheet. I email the property manager that day. Can I schedule an appointment to read board minutes? What is your questionnaire fee? Can the client send you the money directly? And oftentimes they'll have a link. Email the client, please remit payment. I'll have who's going from my office to read the board minutes, take the questionnaire with them. And I'm like, track down that property manager, let them answer it right there for you if you can. So, you know, again, as much info as you can get for us, the better. Oh, this is a really good one. Do you recommend we pull documents from the DOB when taking a listing? How deep should we dive? So what if, you know, I'm doing another CE class on advanced due diligence next Thursday, and I'm focusing more on utilizing technology and conducting due diligence, meaning going through the Department of Buildings website, going through the Department of Finance website, going through ACRIS, and going through a couple other real estate analytical websites that provide, you know, a different angle of what I'm looking at. Today's session's the fundamentals of due diligence, really. So if you guys are interested in that, it's on our website, nyrecenter.com, if you want to sign up. But the reason I bring it up is that when you talk about going to the DOB, one of the presentations I've done, I'm sure at many of you guys' offices over the years, is I walk through each of these sites on a computer. I'll put it up on the screen in terms of how to use them. And I always recommend, if you get a listing, it's more relevant in a townhouse and a multifamily property. But I even recommend doing it in a condo as well. Pull up the deed in the CO. A, you want to see who really owns the property. Are you dealing with the right person? B, on the CO, you want to make sure there's a valid CO on record. And if it's a townhouse or multifamily, you want to see what violations exist. You know, this may sound like a lot of additional homework. It's really not. If you're well versed in these sites, and they're very easy to use, it's a couple minute task. The CO, you're going to look, and, you know, oftentimes there'll be 25 COs listed. When I'm there, I email Nick and I'm like, hey, what's the most recent CO? I can't click on all these and keep track. It's impossible. And they're not in chronological order. It's a whole bundle of a mess on the DOB's website. So the reason you want to find that out is that it's not uncommon that a building's been operating for years and just continuously operating on a temporary certificate of occupancy. I know one now, the Chelsea Modern, which was a pre-recession project, still has a TCO. till today. We're talking 12 years later. I mean, it's asinine, right? And the reason this impacts you guys is because it impacts the closing date you pick, and it's going to impact your client's financing. You know, if you don't structure the date around prior to the expiration of that TCO, and there's a lapse in CO, and your client needs financing, no bank in America will lend to a property that does not have a current CO on it, and you jeopardize the deal. So I know it sounds like, oh wow, this is an extra task. It's something I do it on every deal. I'm representing a buyer, seller. I go further, but because I have to pull out the mortgage to see if I can do a SEMA, things like that. But I recommend you guys do it. The CO and the deed and violations every time.
Pierre, I have a question on that. So the TCO needs to be extended every year, right, with an amendment?
TCO, so at some point, the sponsor is supposed to get a permanent CO for the building. And oftentimes, the AD requires them to hold money in escrow to do that. The TCOs, they're usually renewable in 90 days is usually the number for the most part.
Well, my question is, let's say most developments, there is several years, right, while they still have a TCO at least. They don't usually get their CFO for several years, but they have to renew it every 12 months, correct? My question is, at what point before the renewable date will it be a problem for financing? Will a bank look at that as a looming date?
No, not from my experience. You can close on, as long as it's current on the day of closing. They're not going to look at it and say, oh wait, this expires 30 days post-closing. We want to know what you're doing. I haven't seen that. I mean, look, it can change now, but I've not encountered that.
Okay, good. Because obviously that comes up all the time.
Yeah, no, of course. Do you guys do that though? Pull up the deed and the CO? Like, have you ever encountered any issues? Is that common practice for most? No. If anybody wants to chat about it, I'd love to get people's thoughts.
What we look, hi Pierre, it's Deanna. What we look for very often is, whether or not there are any outstanding permits that weren't closed. That's the big thing for us. We've had so many of those deals, but I don't know if that's for discussion today.
No, I'm glad you brought that up. It's great you do that, because here's the thing about permits. If you're getting a listing and you're marketing the property, let's just say 90 days, right? And then you go into contract for another 60 to 90 days. You're potentially dealing with the property for half of a year. If you can pull up the fact that there's an open permit when you get the listing agreement signed, you have ample time to notify the seller to take care of it. Because if you wait till it gets to my desk, and I'm sure as hell going to pull it up and require it to be closed. These permits, sometimes they're extremely difficult to close, other times they're not, but regardless, they're time consuming. Because you're dealing with expediters, you're dealing with bureaucracy. Why not address it at the listing, at the time you get a listing, have the seller properly address it while marketing the unit and avoid delays in closing? Like I had one once. I represented somebody buying a townhouse. I learned a very valuable lesson myself. It wasn't a townhouse, sorry. I was like a 3 to 4 family in Uptown. And I go on, it was a cash deal. So in a cash deal on a 3 to 4 family, I can close in as quick as 7 days, right? All I need is a title report for the most part. And I pulled up the violations. There's 25 violations. I put in my contract comments, seller will remove all violations as a condition of closing. I made the mistake of assuming the seller's attorney knew the magnitude of the violations before agreeing to my representation. We negotiate the deal, we go into contract, they get a title report a week later, and I email them, how are you doing on the status of the violations? Oh, we didn't realize we had so many. And like I said, it's a valuable lesson for me. So I made the mistake of assuming this person knew what they were doing. So all of a sudden, these violations were all, some of them, I want to say the most recent one was like 2005. They were all close to 10 years, at least 10 years old, somewhere from the 80s and 90s. They just weren't removed of record, and they weren't of substantial nature. So client calls me up, Pierre, I want to close. What are my options? I go, you can do 2 things. One, you're contractually protected. You can wait till they remove all of them and close with a clean record. Or 2, you can close, take subject to, maybe ask for a little bit of a credit, hire an expediter of your own, remove them at your own leisure, or don't remove them and wait, see if your buyer brings it up in 7 years' time when you go to sell. And the risk to you there is that, you get an expediter in there and the DOB there's a slight chance the DOB may come to the building to verify, and they may find something else wrong. So, in my opinion, I think you're better off waiting, but again, here are your options, your decision to make. Client ended up waiting, and it took, I want to say, 60 to 75 days to remove the violations. So here we are on a multi-million-dollar deal. The seller had 75 days of opportunity cost of not having the funds liquid, the liability of carrying the property, and we all know the great saying in life, time kills all deals. This all would have been mitigated and avoided if you just go on the DOB website, notify the seller, here are your violations, get an expediter, take care of it while we market the property. I think that's, the best way to go.
Will you be covering that in your, yeah, I think so too. I just think we need to have, and maybe in your next week seminar, just some instruction as to where to look for that. It's not easy. We've had attorneys and we've looked for it, and then all of a sudden the bank comes up with something that no one else caught. And that's where we get into trouble.
Yeah.
Pierre, what about if it's a landmarks violation, and let's say you were representing a buyer, what would you recommend to them to do to be able to close on something, but to be able to protect themselves?
So we're talking a scenario of a townhouse.
Yes.
I would ideally like to know before we sign what would be entailed. Well, it depends. If the seller is willing to remove the violation, then it is what it is, and the only risk to us is that there could be a delay in closing given the time it takes to remove it. If we're taking subject to, then we got to hire a landmarks expert to go there and give us an assessment in terms of what would be entailed to remove it.
And then you just hold back those funds, the amount of those funds, is that it?
Depending on the business terms, like if the seller's obligated to remove it, yeah, we can hold an escrow. Sometimes depends on the market, right? In a bull market, it's take it as is.
I'm talking about now. And should the buyer then want a credit for the amount of the estimate to fix the violation? If the buyer and seller want to close, but there's a violation and it happens to be a landmarks violation and it's a house, now what? And you're representing the buyer, what should you ask for?
Well, if they don't want to wait for it to be clear to close, then ideally we would hold an escrow sum of at least 2 times the amount of the estimated cost to remove the violation. And we would give the seller a fixed period of time to remove it. And if they don't remove it, we're entitled to do it on our own using the escrow funds. Presumably by holding at least double the amount of the cost of removing it, the seller has a vested interest in doing so because they want the balance of the money. Right. So, depending on the magnitude, I've been in scenarios where I've requested 4 times the amount to be held in escrow. It depends on the severity of the violation and the cost. Oftentimes we'll live with double, to be honest with you. But that's how, and then, we'll be in a situation where the parties both say, you know what, we don't want to deal with each other after this. I just want to be done with them. I can't stand this person. Just give me a credit and I'll live with it and I'll figure it out.
That's what I'm asking. You ask for a credit, is that it?
Yeah.
If the buyer is willing to deal with the violation after closing.
Yep, then it's a credit.
Credit for what? For the amount? You're saying, well, it wouldn't be 2 times the amount, or what do you ask for?
To be honest with you, it's kind of horse trading, with
Yes, that's why I'm asking you.
Yeah, there's no magic formula. We're not going to ask for double. That'd be unreasonable. Maybe you ask for, 20% premium, on what the estimated cost is. It all depends what you can get. There's no magic formula. We would go in with 1.5 times to start, probably. Don't want to do anything, egregious. So we're not looking like we're trying to kill a deal. But, we would go with 1.5 times and just barter, to be honest with you.
Thank you.
Yeah, my pleasure. So another great question I'm seeing here. How do you discuss real estate taxes with a client before they sign a contract on a resale or for new development? So part of that seminar I'm talking about going through ACRA's Department of Finance, Department of Buildings website, is to go through the taxes. So we pull up the tax bill for any real property. In the tax bill, if you go to the second page, it shows you taxes with abatement, taxes without abatement. And why this is extremely important for you guys is that about 5-6 years ago, the Department of Finance revamped the 17.5% abatement that all co-ops and condos got. So probably like in the early to mid 90s, Department of Finance came up and they said, you know, our formula is inequitable in terms of how we calculate property taxes for townhouses and single families versus co-ops and condos. We're going to give every co-op condo unit owner a 17.5% abatement on our formula. Ask me how they came up with that. I don't have the slightest clue. They just came, that was the magic number. Now, backtrack to 2014, when our market became even more foreign investor driven, where all these shiny glass towers came up that people call ghost towers, where New York City had more pied-a-terre investor, demand than ever before. Department of Finance came about and said, why are we giving people who are affluent that can buy, multi-million-dollar second homes a break on property taxes? So they phased it out where only people who occupy their unit as a primary residence are eligible for that abatement. So if you get a listing, don't go off the taxes necessarily your client pays. So if your client is a primary occupant and the buyer's coming in as a pied-a-terre owner, the buyer's going to pay 17.5% premium on the property taxes. So you want to take the property tax bill, and I always recommend you indicate the higher sum, but clearly you want to preserve the marketability of the discount because most people are primary occupants, and you disclose, if this will be your primary residence, you may be eligible for 17.5% abatement. Please consult your lawyer to discuss. That's what I always recommend, because I embrace the marketability aspect, but I also want to protect you guys liability-wise. So when you do that, I think you're pretty much covered. Secondly, tax abatements on properties. There's a common misconception that it's a fixed increase as time goes on. So you're buying in a building where the building was built 7 years ago and they had a 15-year tax abatement. And taxes are going to phase out 20% every year from years 11 to 15. And the buyer's going to come and say, well, I'm going to be living here by the end of this abatement. I want you as the broker to tell me how much the tax is going to be. I want you as my lawyer to tell me how much the tax is going to be. Can any of us answer that? No shot. No, there's no shot in hell. You'd be picking a number out of thin air. And the reason being is that you can't take today's assessed valuation and just increase it by 20% over time, right? Because the formula is based off of a credit on the assessed valuation at that time. So the taxes can go up far more substantially than 20% on a phase-out year if the assessed valuation increases substantially. So there's no magic formula. All you can tell them is if the assessed valuation remained what it is today, this is what your taxes would be with no abatement. Because the bill gives you taxes with abatement, taxes without. So you can say, look, you're going to be subject to the assessed valuation fluctuating just like the rest of the city. But here you go. This is what your bill would look like today if no abatement existed. That's all you can give them. And you give them how many years are left on the abatement in the formula. And the Department of Finance website has a component to it which tells you how many years are left on the abatement. And it gives you a graph in terms of what projected, phase out and valuations are. But that's all subject to change, right? Like there's no guarantee you can make on any of that stuff. On this topic,
will you be going over that, Pierre? Will you be going over that in the class next week, where you can get to that Department of Finance website, with the graph and so forth?
Yeah,
okay.
for sure, definitely. So that's how I explain that one, and we're gonna get clients to say, well, I'm not comfortable unless you can guarantee me what taxes will be, and no one can do that. It's not a realistic request, And I know that's a very common question that you and I both get all the time. How do you guys deal with that one? Because that was one of the questions that was emailed to me. How do you guys
Pierre,
deal with it?
I actually emailed that question, and I think your explanation is really good. It's the best explanation I've heard for the 421A tax abatements.
Well, let's end the class now. I want to go out on that note. I'll see you guys next week. Yeah, I'm kidding. Thank you, Sean. I appreciate that.
Actually, though, I had another comment. Usually, we would feel pretty good about co-op taxes. They stayed pretty stable, long-time co-ops. But I'll tell you, my co-op, long time, old-timey loft co-op, we just got a 20% increase on our taxes this year.
Wow.
So
Wow.
that is really unusual.
Are you hiring a tax certiorari lawyer to dispute
Yeah,
it?
we'll have to do a certiorari, you know. And your point is a really good one about this 17.5% situation. Every co-op, I'm sure, is dealing with it differently. In my building, what we've had to do is we had to raise our maintenance to include the fully assessed taxes.
Mm-hmm.
And then at the end of the year, the people that are, because we have two people, it's not their primary residence.
You assess them the difference. Yeah.
No, I think we reimburse the other shareholders.
So typically speaking, like I live in a co-op, and every year we get the 17.5% abatement, and then it's offset by an assessment. So it's a wash for me as a primary occupant. The building takes the money. In a situation where it's not a primary occupant, they just get the assessment. So basically they get assessed what that 17.5% delta is because they're not a primary occupant.
That would have been a good way to do it.
Yeah, that's typically how it's done.
Yeah.
And also too, another thing on this topic, have you guys heard rumblings that they're thinking about doing away with the 17.5% entirely?
I was just going to ask you if it was 17.5% that they were talking about. Is it that they're talking about?
Yeah. Has anybody heard if it's being passed? I haven't heard it. Last I heard it was just,
I think it's been pretty quiet recently.
Yeah, I mean, to be honest with you, I can't imagine, and I don't want to, I say this delicately, I can't imagine in this year with everything we're going through, Department of Finance taking a measure of that nature. But, for those of you guys who did this during the financial crisis, property taxes went up that year, right? How did they go up? The world ended for a while. It was the worst financial crisis since the Depression. So I can never.
And we're in a position where the state is going to need money, and the city is going to need money. Yeah.
I wouldn't be surprised in the near future if they scrap that abatement entirely, and they say we don't know why we ever gave this. Abatement's gone, and that's going to result in a 17.5% increase. It won't be straight 17.5%.
When did that?
Pardon?
When did the abatement go into effect? What year approximately?
It was either 1994, I want to say. 94 or 96, one of those two.
Thank you. Yeah.
So guys, we have about 10 minutes left. Anybody have any questions you want to chat about that we did not go over? I've covered almost everything I've wanted to cover.
I want to ask, what's the name of that abatement? Because people refer to it differently. What's the abatement called, the 17.5%?
I call it the primary resident tax abatement and 17.5% to clarify. I use both.
What was the second one?
And 17.5%. The primary resident tax abatement of 17.5%.
Can you also talk about the STAR tax abatement? Is that the same thing or different? That's different, right?
The STAR is a nominal sum. It's what is it, like $350, $500? How much is a STAR? I don't even remember the last time I got it. I believe the STAR has to do with schools, but I'm not too familiar with it. It's more of like a bonus thing that people get that they don't really pay much attention to.
Okay, thank you.
Yeah, no worries.
So are you going to go over looking at the permits online in the class next week? That's the main thing I'm curious about. Yeah,
well, what I'm going to try to do, I got to see, it'll be my first time doing it on Zoom is the problem. So I'm actually probably starting to go back to the office next week, and I'm going to try to pull up on my computer to go through it where it pops up on your guys' screens what I'm going through. I just got to make sure, I can figure it out. But yeah, it's my intention to do that. I'm doing these now on my iPhone because my laptop, I can't figure out how to get the microphone to work, and I ordered one. It's been in the mail for like 3 weeks, so we'll see. Cool. Anybody else have any questions? Or, I mean, how's everybody doing with due diligence now? Is anybody working any active deals at the moment?
Well, we just had one managing agent finally send minutes, by email to the attorney. So we are having some progress on certain things. I think they're pretty much, it took us a good 2 weeks, 3 weeks to get.
Yeah, I know it's crazy. How did they do with the questionnaire on that deal?
They actually got the questionnaire to us sooner than the minutes, maybe because that's sort of standard, and the minutes sending out the minutes is not.
Right.
But the board
right.
is pretty reasonable.
You're lucky that they were able to do the questionnaire, probably given the fact that they're remote right now. So you're lucky that
Pierre, what we did is, number one, our owner, who's a shareholder who had served on the board, really, they got involved with getting this done and getting this done in a timely basis. I think the shareholder sort of has more leverage than we, a broker, do. Number one. And number two, what we asked for was, there's a standard sheet that basically has standard building information about each of these buildings.
okay.
How many units, how many this, how many that. We asked that they just send us their standard sheet, that, their cheat sheet, basically, with all the answers about a building. We asked them to send that, which answered almost, pretty much most of the questions, if not, 90% of them.
Right.
So that was very helpful to get the standard sheet from the building.
Yeah, I recommend every time get the standard questionnaire. I mean, so every now and then I look at it and I'm like, this answers the majority of what I want. That's one of the good things about having them. Say hi. My oldest son's crashing our class. Say hi, buddy. All right, now get out of here. All right, you gotta go. Go. See you.
I have a quick question, and it's kind of a complaint. And I don't know if this is typical, but it just is so outrageous to me that when you're doing a deal and the managing agent provides a questionnaire to the bank and they get a fee, then when the appraiser needs a questionnaire, they charge that fee again.
Yep.
It's the same information. That is so outrageous.
I know. I know.
And then the bank won't share it. The bank cannot ethically share it with the appraiser.
Right.
I mean, there should be a law against that kind of thing.
Oh, good luck, Sean. You'll be waiting for years. I know it's ridiculous. It causes so much, undue angst and delays in our deals. But there's really nothing you can do at the moment. The banks, everybody's gonna have a couple different questionnaires, and that's how they monitor it.
Is there any hope for that getting more systematized? I know that, like, on Element's site, they have the board packager thing where you can get the financials, and I mean, I'm on the RLF board, and we're trying to see if we can get managing agents involved to accommodate that, because it's so unwieldy and it wastes so much time of everybody's time. So just curious.
Anybody have any thoughts on that one?
It's an ongoing problem for all of us, and I think all we have to do is just continue to try and see if we can collectively think and try to craft a way, either through an existing platform or a new platform, to try and eliminate the craziness that goes back and forth. I mean, selling houses is so much easier than doing this. It's crazy. People spend so much time. So I don't know if there's a way, but I feel like there's got to be a committee to explore it, whether it's attorneys and agents or attorneys managing agents and agents. It's something, you're busy. We're not as busy, unfortunately. And it's something I've been thinking about. So I'm putting it out there. So
I would love nothing more than to have this process more streamlined and hold managing agents more accountable on this. I'd love nothing more and make all our lives easier. I've always hoped, Rebney or somebody would get involved and try to help, create some parameters. But the problem is managing agents aren't, who are they accountable to? That's the problem. They're accountable to the boards. So it'll be a tough fight to fight.
They also advise the boards, and the people on the boards and the people in the building who are being hurt by this could get together. But I don't think there's enough of a collective. There must be an answer to this. Maybe Stuart Saft or somebody who deals with the Council of Co-ops and Condos. Something needs to happen. It's insane.
Yeah, I agree, because, if you're on the board, the problem is inevitably it will impact you when you go to sell. So that's the thing. But however, when you have your long laundry list of items to address, are you really thinking 7 years down the road or 5 years down the road or wherever the case may be? I agree with you wholeheartedly. I've always hoped that, somebody would take the initiative to get them to do this. I've always been at a roadblock of who's the right person to do that.
Maybe it's something we should start talking about more on different forums so that we can get some action on it. I mean, I'll certainly continue to talk about it, and anybody else should as well, as they see it's appropriate with the right people.
I'll brainstorm myself because I've always been, honestly, I've thought about it a number of times over the years. If we've answered everybody's questions, I'm good to go on my end. Thank you guys so much for having me today, for doing this. I'm loving doing this every week. So you guys want to keep going. The goal is to keep doing this during the entire shutdown. I will disclose Zoom puts on 10 pounds. This isn't me having to, just be gorging for the last 4 weeks. So I'm blaming this on the phone. Hopefully we see each other all sooner rather than later. I think Anna, we're gonna chat about whether, if you guys like doing the CEs for an hour and a half, switching it up with Q&As, maybe every now and then do a shorter session. It wouldn't be accredited, but if people, don't feel like sitting on the phone, on the computer for this long, I'm all ears. So any ideas you have for what could be helpful, please let me know. Anna, thank you for coordinating. Nick, thanks so much for coordinating for, your important, aspects you chimed in on today. And stay safe, everybody. Thanks, guys.
Thanks, Pierre.
Thank y'all so much. I appreciate a great session. Be safe.